We recently talked about the fact that law needs to be subdivided into lots of different categories. One of the most important categories for the criminal justice system is what we call substantive criminal law, though usually that term substantive is dropped off the term and we just talked about criminal law. In other words, when you hear people saying criminal law, most of the time what they really mean is substantive criminal law. So what is substantive criminal law? What it does is it defines actions that may be punished by the government. In other words, it defines the crimes legally. And as you might remember, that does include having an attached punishment. Remember, this is quite different to civil law, which deals with wrongs, not crimes. So as we saw in the case of President Clinton testifying to the grand jury, and remember that President Clinton, before he became president, was a lawyer, words really matter. And as a matter of law, however politically expedient people might have thought it was, he was correct to say it depends what the meaning of is. Likewise, we see words really matter in the definition of crimes. So where do these words and laws come from? We call this compilation of laws the criminal law or the penal code, and as I hope you are well able to predict now and you're ready to mouth along with me, exactly what those criminal laws are depends on the jurisdiction. We've said this again and again, and we'll say it again in the future. Different jurisdictions of the United States have different definitions of what the criminal law is. They'll have different names, different degrees, different content, different definitions. We'll find that most crimes do have what is referred to as elements in common. Most crimes have at least 4 different elements in common. Let's list them, then explain them. Actus reus, mens rea, concurrence, and causation. So what do these all mean? The act is the idea that somebody actually does something that violates the law. Hopefully you remember that this can be an act of commission or omission, though more often it's likely to be an act of commission. But it is a thing that is actually done, or in the case of omission, not done. The really interesting and complicated element in many ways to talk about is mens rea. It is very often translated as a guilty mind from the Latin, or more colloquially, or more in terms of how we might understand it, is intent. So we'll treat mens rea as the intent or the mind that a person had in order to commit the crime. In practice, I think it's most helpful if you understand intent as existing along a continuum. On the one side of the continuum is when you actually want to achieve a criminal outcome, such as planning and executing a homicide. At the other side of the continuum, you don't actually want to commit a crime, you don't actually intend a crime, but you did something that could foreseeably result in a crime, and therefore you are still criminally liable from it. Think of something like driving under the influence of alcohol and killing someone as a result. So we see that intent, or mens rea, is actually pretty flexible, and we can illustrate that by looking at different ways people might be legally culpable of or legally liable for the death of another person. At the most extreme version of mens rea or intent, we have something like first-degree murder or premeditated and intentional murder, which often goes with the phrase malice aforethought, where somebody planned and intended to commit a murder. So if first-degree murder is premeditated and intentional, second-degree murder in some jurisdictions might be something that is intentional but not premeditated. So it's somebody who acts in the moment. Sometimes there might be a lesser degree of culpability because the context that a person acted in might be more understandable. It doesn't make it less criminal, but it might mitigate the severity of the crime in terms of how it's charged, or later on in the system of how it's sentenced. An example of that might be somebody who kills somebody in the context of discovering infidelity. Somebody walks into a room and discovers her husband in bed with another woman, picks up the lampshade and hits the husband or the girlfriend over the head and kills them. That might be charged as voluntary manslaughter, because although it was intentional and that you knew you were going to or trying to kill somebody, and killing someone or hitting someone over the head could result in their death, it is understood as being motivated out of a kind of passion which decreases the criminality. It doesn't make the person not guilty. At the lowest level of mens rea is something like when you engage in an action that could result in a death, but there was no intention to cause the death. That might be involuntary manslaughter or negligent manslaughter. And here the classic example is when you drive under the influence of alcohol and you kill somebody. Your guilt comes about because you knew in driving drunk that result of death could result, even though you never intended to commit the crime of killing somebody. One of the things that you can see over here is these different understandings across the spectrum of mens rea relate to the ideas of mitigating and aggravating circumstances that arise more often when we talk about sentencing and punishment. So we can see connections between these different parts of the criminal justice system through the logic of what we might understand. We can also see another aspect of the criminal justice system and the trial system coming in terms of defenses, because the degree to which we have a defense, or the kind of defense we might have, is itself going to be shaped by mens rea, and we'll talk more about that when we talk about defenses. Because we spent a lot of time talking about mens rea, let's review very quickly these different elements of a crime. So most crimes are going to have the act, the intent, so actus reus or mens rea, but then thirdly, and this might sound redundant, but it's an important part of the law, it will have to have concurrence. In other words, the act and the mental state need to occur together in order for the crime to take place. But if we think about the need for there to be a consciousness in the act and not just an accident in the act, we can see why concurrence is so important. A final element that we find in most definitions of crime is something called causation. A crime has to have resulted in a harm, and that harm needs to be linked to the act. So let's look at an example over here to underscore this point. Say, for example, somebody shoots at somebody, and although they intended to kill them, they don't kill them, they merely graze their skin. And the person goes off to the emergency room to just get attended to, and they're released the same day. But the emergency room doctor who attended to them had unintentionally transmitted a deadly infection to that person, and that person subsequently dies of that infection. Can the original shooter be charged with the murder or the death of that person? In the theory of causation, the answer would be no, because even though the person intended to kill somebody by shooting them, they failed. So they could be charged with attempted murder, but they can't be charged with murder because the death of that person could not be foreseen through the actions or inactions of the emergency room physician. So the court needs to be convinced the accused is legally liable. And in that example, a person certainly could be charged and found guilty of attempted murder, attempted first-degree murder. But they could not be charged with the death of a person if they actually died because of something that happened in a chain of events that they could not have predicted. These elements of the crime are very important as parts of the principles of criminal law. So mens rea, actus reus, congruence, causation, other things we haven't talked about, like attendant circumstances, something we'll talk about later, like punishment, are all very important parts of principles of criminal law, as is the idea of legality. Our earlier mention of President Clinton underscores a very important idea of the principle of legality, that in a system of the rule of law, everyone living under the rule of law needs to follow it. It doesn't matter if you're a president or a professor, a prosecutor, a prostitute, or a police officer. Whoever we are supposed to follow the rule of law. Another principle of legality that's very important is that the criminal act must be prohibited by law before it was committed in order for it to be charged as a law. In other words, the US Constitution prohibits what we call ex post facto laws, where criminal laws are made up after the fact of the action in order to, after the fact, go and prosecute somebody for an act that they could not have known was a crime in the first place. And that's a good example also of a protection that comes from the original Constitution rather than the Bill of Rights or a subsequent decision by the Supreme Court.